We're live.
All right, good morning. It is February 26th. Senate Judiciary, we are picking up at 22. We have Chris Bradley here to start us off. We have about half an hour. We also have Major Sloan from the Vermont State Police. Going to try dividing it for about 15 minutes for both, if that works for folks.
This will be very quick from my standpoint.
Sounds good. So yeah, floor is yours. Thanks for coming in.
Good morning. For the record, my name is Chris Bradley. I have the honor of representing the Vermont Federation of Sportsmen's Clubs. We represent 50 fishing game clubs across the great state of Vermont with approximately 14,000 members. Thank you for the invite to speak to S22. In listening to the sponsor's rationale for putting this bill forward on February 19th, we believe we understand that the reasons for this bill were as follows. 2 houses in Waterbury were taken over by drug dealers. These miscreants began shooting firearms on their property. The problem property was adjacent to a daycare, and law enforcement and town officials both said there was nothing they could do. As an aside here, Waterbury opted to disband its police force in 2018 and now contracts with the Vermont State Police for police coverage. And we further believe that the problem no longer exists because the bad actors moved away or were otherwise dealt with. In researching this issue, I began by checking with the Waterbury town clerk to inquire as to whether Waterbury had a noise ordinance. They do not. In my hometown of Northfield, we have a noise ordinance for 23 years. I participated in drafting it, and I also participated in revising it last year to specifically address a situation remarkably similar to what Waterbury experienced. The amended ordinance solved the problem by giving law enforcement the tool they needed to stop the activity. End of story. Northfield's disorderly conduct ordinance addressed the discharge of firearms within Northfield, with this ordinance fully complying with 24 VSA 2295, which is, I refer to the Sportsman's Bill of Rights, or the preempting statute, as well as granting some exceptions. If you're not familiar with 24 VSA 2295, this is Vermont's preemption statute based on what is referred to as the Dillon's Rule, a rule which constrains a municipality's ability to regulate firearms by limiting municipalities to only controlled discharge. Setting aside any incredulity of Waterbury not having a noise ordinance, the fact is the existence of such an ordinance would easily solve the issue, which is a apparent basis for this bill. To be clear, Waterbury already has the power to solve this problem at their local level, just as every other municipality in Vermont does. Well beyond that simple fact, the expansive nature of this bill is overwhelming. For example, and again using Northfield as an example, town records show that the Northfield School District owns 9 parcels of land, some not contiguous, which total 164 acres, with one of these parcels having 120 acres. With a 500-foot offset in all directions from around 164 acres of property, it can be easily appreciated that a sizable portion of land in Northfield will be affected, which in turn affects hunting and the lawful discharge of firearms in a safe manner on one's own property or with the permission of the property owner. As another consideration in Northfield, we are home to Norwich University, with Norwich University owning approximately 43 properties, some non-contiguous, for a total of over 1,320 acres. That is over 1,400 total acres which would be affected, plus the land covered by the 500-foot offset. And that's just Northfield. How would a hunter know that they would be in violation if they shot a deer unless they memorized every school property line and then calculated the 500-foot offset? UVM would surely qualify as a school, and it owns 14 parcels of land across Vermont, almost all non-contiguous, including, and I list the properties, for a total of over 3,000 acres. Over 3,000 acres of property, plus the 500-foot offset. This ridiculous amount of land where hunting and lawful discharge of firearms would be prohibited. Further, if drugs were indeed involved in the situation that spawned this bill, If any situation existed where drug users were in possession of firearms and existing laws could have been used because drug dealers are prohibited for people. That's per 13 VSA 4017. Not to mention 13 VSA 1025, reckless endangerment, or even 18 VSA 4253, use of a firearm while selling or dispensing a drug, may have been applicable. But we are certain the Vermont State Police would have considered these and possible other existing firearms laws. At least currently, we have some very rural schools, and we also have some very rural daycares. Do we know if there are any existing shooting ranges which are safely oriented that will be closed because of close proximity to a piece of land owned by a qualifying daycare or school? And would this apply to indoor ranges? This bill will require an inordinate amount of time to fix when the simple and straightforward solution already exists, which is to have Waterbury Select Board do what should have been done over 20 years ago, which is to enact a noise ordinance. The Federation strongly opposes this bill as written, as it is completely unneeded. Waterbury already has the power to control the problem, not to mention that this bill is written without any real regard to the sheer amount of property involved, as well as completely ignoring honored tradition, hunting, the lawful use of firearms in a safe manner. Just for the record, I submitted the Northfield noise ordinance. It started as disorderly conduct ordinance, but spot on addresses in the zone, basically high density zoning areas were prohibited from shooting. However, there were carve outs for, say, the dispatch of problem animals or diseased animals. Any questions for me?
Thank you.
Thank you so very much. Appreciate your time. Thank you.
Just a few
Yes.
comments, maybe questions. I think that in regards to the land, the amount of land on different borders, I believe that was raised last time as an issue. I mean, I think it's something that would need to be clarified in terms of, you know, if you have a school building that's obviously a school and they own a piece of property somewhere else, how is somebody going to know that they're necessarily on that distant property that may be owned by the school? What I would like to try figuring out, if there is a path forward, how do we differentiate between an obvious daycare center or an obvious school versus just another random piece of property that the school district might own? And so that's, I think, one of the pieces. But the other piece is regarding the mental element that's required in this, which is knowingly. I'm trying to make that apply to whomever may be doing the shooting. So this element, this knowingly element, is you have to have the understanding that you are obviously next to a school. You know, if you're deep in the woods and across the road and through the trees, there's a daycare center that doesn't have any obvious signs that it's a daycare center, and somebody's shooting in an opposite direction. I don't think there's an argument to suggest that that person is knowingly discharging a firearm next to a school because they don't know that it's a school. But if you look at a different scenario, you've got two buildings next to each other. One's a daycare center with a big sign out front, playground in the back with kids running around on a regular basis, and somebody's firing off guns, like the example of Waterbury. That's a different set of circumstances that I think would fall under knowingly standards. But so, yeah, I guess there's not a question there, just some initial comments. So,
I take Chris's point about the 500 feet offset, and I'm remembering discussions over various bills about school property. Property itself is problematic because some schools have expansive property. And so here we're not just dealing with the property, we're then adding 500 feet in a buffer all around. And I do think that's problematic. In other words, this bill as written doesn't strike me as, it does seem like it would need a great deal of nuance and to go through. On the other hand, it takes me back to a bill that I put in 3 or 4 years ago, which would have banned guns in childcare centers, and we couldn't get that through. That seems to me more worthwhile, in some ways than what this is attempting to do, because I take Chris's point also that a noise ordinance could potentially deal with this if that's what we're trying to deal with, is the noise rather than the danger of bullets. So I find myself looking at this and saying, we're talking about discharge within 500 feet of a childcare center, but people can still openly carry into a childcare center, which just, as Chris knows, is something that I find hard to understand. So I guess what I'm saying is I see Chris's points here, and I do think this would require quite a bit of work to make sure that we don't create what might in a court setting turn out to be an unlawful infringement.
Senator Bowles.
I would certainly support adding carrying a firearm into a childcare center, but I think one of the things we talked about last time was sort of the idea of real property, not land, but actual buildings. That sort of dealt a little bit with what I hear you and agree. Like, as you pointed out, the Northfield School owns 9, I think you said 9 non-contiguous. But really what we're talking about is the actual building where kids are, not necessarily, a piece of land that they're not using. And so I think there are ways that this could be sort of dialed in to get at the intent, because I think we probably should be talking about the danger of bullets, not just noise.
Well, we have a reckless endangerment, so when pointing at a firearm at another, I guess I was, to your point, open carry versus concealed carry, I think is what really was the issue on daycares. That they didn't want to be in a situation where they're monitoring kids and people are coming and going from parents are picking up their kids. And I think both buildings and grounds, because there was we wanted hospitals, buildings, and daycares.
Yeah.
And buildings and grounds came in and said, we already have this, we're all good. As did daycares. So those two were taken off the table. I think when somebody's acting out and they fire in a dangerous manner, I think we have laws that take care of that. If it's an endangerment issue, certainly you can immediately control it with the noise ordinance. Sorry, you're high density. No. But I think the aspect of danger is what we're really looking at here. And I think that's covered. Certainly nobody should be high power shooting in any unsafe manner. And I did not look at this property. This could have been, as I gathered, they were shooting into the Winooski Riverbank, which is not a safe environment, in my opinion, not only close to water. So it just struck me that I understand the intent of the bill. Federal law gives us 1,000-foot setback, but you have an intent, you've got to be doing something wrong. Another aspect of this is school buses. A school property. As a school bus travels around, just delivering kids. Is that 500 feet from a moving school bus? So I'm not trying to split hairs, and I do understand the intent. The devil with this one is, I think there are better things in our time to, and I think we've already got this pretty well covered.
Thank you. Any further questions? Great. Thank you.
Thank you very much for your time.
You. Next up, we have Major Loan from the state police.
Morning. So my name is Sean Long. I'm the major of the state police and the criminal division commander. So I can see all of the detectives, narcotics, and major criminals. So what I wanted to do was provide some data both about the 500-foot and 1,000-foot, which is the federal standard for Vermont in particular. Right? So 2022 to 2024, we're going to use the 500 rule. We had 5 homicides within 500 feet of a school or a childcare center. If we use the 1,000-foot rule, it opens up to 11 homicides. So we're looking at this focused on criminal use of firearms. So now when we record our data, we're not looking at legal use of firearms. So what we do is we collect data on firearm threats, firearms use, hit by bullets, and property hit by bullets. And we read all of the reports to make sure that in this situation, it's the illegal criminal use of a firearm. So we don't take, if someone said there was shots in a cornfield at 6 a.m. in November, we do not count that. If there were 3 shots on North Ave and there's a bullet hole in the car, we count that. So that's where we get our data. So what we were looking at doing was introducing the idea of some of the language that's in the federal statute, which I think is very effective. So in 18 USC 921, the term school means a school which provides secondary or elementary education. It's not specifically property, it's the building, which is a big part of this conversation. I think could alleviate some of the other issues. The other thing that it mentions though is it doesn't apply the discharging of firearm on private property, even if within 1,000 feet, if it's not knowingly or recklessly endangering people. So the idea is if you were to hunt within 1,000 feet of a school property on private land legally, you would still be not in violation of that law. And it would allow people to still exercise their rights and have, say, a shooting range or indoor range, or even say a school has a target team or a skeet team that they want to have that's on school property. So using some of the law that's in the federal statute, it allows for, like I mentioned, you've got the anything that's part of a program in a school zone is not covered. So a school program in a school zone isn't covered. Individual in accordance with a contract, so any kind of security or police that are contracted, also law enforcement acting in their official capacity. But the language that I think is important is knowingly or with reckless disregard for the safety of another to discharge a firearm. And I think that's where it changes some of the intent of the bill. Because I think what we're looking for is people that are putting people in danger criminally, the criminal use of the firearm, as opposed to just the use of the firearm. So I just wanted to present that just very briefly and add that conversation. But there may be an opportunity to look at some of the federal law. And even if we choose to not go with 1,000, we go with 500, some of the language in there is helpful.
Thank you. That is super helpful. Some of my initial concerns were also some of the points you raised, like a shooting team or a hunter safety course, for example, that might be happening on school property, for instance. So I think that definitely warrants a look at the federal statute to see what we can bring over from that to make this a bit more clear. The sense that I'm getting just generally for the committee is, we are quite close to crossover, and we do have a number of other bills that we've been working on quite a bit. I think this could definitely be worth revisiting in the near future, or perhaps next session, but mainly because I think there's, as mentioned before, there is definitely some work that needs to be done on it. But those are my initial thoughts. So, committee, any questions?
Good morning. Quickly, in a few years that I was involved in, when Vermont State Police had contracts for township and so on and so forth, and I think Waterbury made it be unique as far as the cops contracts used to be run. But at that time, Vermont State Police would not enforce municipal ordinances as that policy changed. It has not changed. That's the question that I have. Thank you.
Any further questions? Good. Well, thank you. Appreciate your testimony. Maybe we'll be switching gears here. Go back to S12, our favorite bill, and